Hello to everybody. I'm glad to introduce myself. My name is Amelia Bongarzone, coming from Italy. I deal with research at University Magna Grecia of Catanzaro, where I'm teaching private law and also theory of gods and collective properties. Thanking all of you that will watch this video. I take the opportunity to talk about a new aspect of human modernity, concerning the technological digital revolution lastly experienced, which proposes new scenarios of interest to civil law, involving the methodology of studies and the training of the scholar. Some innovation, including the artificial intelligence, are already current and affect the core of private relations, namely the contract, the rights of personality, civil liability profiles, to name a few. It becomes of primary importance to understand how, in the various sectors, civil law has to regulate acts implemented with the aid of technology, which in many cases will replace human conduct. The game is played between needs certainly deserving of protection, which, however, in their meeting and not infrequently collide, call into question an algorithm not easy to reach. On the one hand, it should be noted that new technologies could bring about a significant improvement in legal standards, proving to be a source of progress and innovation in terms of public and private benefits. On the other side, highlights the exigency to protect compromised legal situation. The automatism of the used mechanisms exposes to risk to fall back into the old syllogistic reasoning that so much has been tried to overcome. To put in with an authoritative doctrine, pragmatism and ancient and new formalism are the dangers of always. Faced with such challenges, scholars have to respond with caution, become aware of the technical aspect, and address their problematic perspective. For this to happen, it is necessary to intervene on time, accepting the challenges of an innovative and technologically advanced society. But in which way? By developing the sensibility of the learner, accustoming him to the problematic nature of the contents, to the critical knowledge of the methodologies that inspire it, without indulging in a sterile notionism, in the awareness of the unitarity of the teaching and researching, convinced that the legal phenomenon is a dynamic aspect of the complex culture of a community. The concerns of a scholar of civil law are understandable, even to the extent that it is usually up to him to introduce the legal science, measuring himself, therefore, with the technological revolution, with the progress of the cognitive methods and tools used, which it is necessary that always remain at the service of the person, avoiding dangerous turnarounds. Such a perspective warns, for example, of the risk that a methodology based on a mechanical aseptic insertion of the data in a negotiation or decision-making process based on an algorithm system can lead to a sort of digital formalism. But law is not mere technique, so it regains strength, the centrality of a debate on method, about the dialectic between facts and norm, on the importance of acquiring a critical conscience towards reality, also legislative reality, firming considering the pact of a human coexistence bound to the centrality of the value of the person. Technology as a function of humanity and not humanity as a function of technology. It is necessary to train the ability to react to the neutral evaluation of concepts, refusing a validity sub specie eternitatis of legal notion and categories, if only for the ambiguity of which is afflict every language, including legal language, often hovering between the meaning attributed to words by the technical language and the common one. In all this, it clearly outlines the commitment that is required to the scholar to be able to respond to the need of the new, understanding when and in what way, but above all, within what limits and with what consequences. For example, in point of responsibility, the technology based on if and then can really be considered appreciable. According to some, the formula of if and then, which when a condition is determined leads to the scheduled effects, make it possible to contain, for example, the problem of contingencies, ensuring the preservation of the initial contractual equilibrium by generating a neutral judgment. But are we sure that a mathematical alignment of a quantitative algorithm is always the preferable way? And are we sure that a calculable, rational, technical law overcomes the conquest of a law that reaches thoughtful, reasonable, and never dehumanized solutions? A first reflection suggests that once again, generalization must be avoided so that, e.g., if it's true that smart contracts can be used in the contractual relationships inspired by needs of certainty and calculability, must instead be considered inadequate and impracticable with respect to all the agreements that require flexibility. And then, here is the reemergence of the role of the scholar and the necessity of his training. Right from the beginning, in the university classroom, with a content reorganization of teaching in a symbiotic performance between theory and practice, research and application, so as to determine a critical and problematic approach to the legal phenomenon, acquiring awareness of the constant struggle between rigidity and flexibility that govern the system of human relations. Thanks for your attention.